Hi, Juno News. Alexander Brown here, host of Not Sorry. Great to be back for another week. I'm the director of the National Citizens Coalition. I'm a writer, a campaigner, communicator, and always thrilled to be here and really excited for you to take advantage of this promo code, junonews.com/not sorry for 20% off. It's a good one. There's so much great reporting at Juno News. Always happy to talk about it and share that work. We have a lot to discuss today because anything but ordinary Canadians, concerned parents, are common sense, classical liberal, conservative, even libertarian minded. They have every right to be concerned. We have a free speech chill continues in places like the UK and Canada at present. And we have real questions to ask ourselves in regards to, what are we willing to fight for? And can we stand firm enough to prevent some of the cultural and free speech backsliding of the past few years? Juno's Melanie Bennett has a terrific new episode on what's happening in the UK right now and what could soon be coming to Canada under bills like C9. Can rude speech about migrant crime get you 2 years in prison? Why are English flags ripped from citizens' hands as hate symbols? And is digital ID a kind of revenge against a populist uprising? And could that happen here? In another piece for Juno News, Sue Ann Levy writes about the Toronto schools swapping arithmetic for inappropriate levels of social indoctrination. Fifth and sixth graders are allegedly being sent to weeks-long workshops on racism, as if they are guilty of anything of the sort at such an innocent age, and as if it's appropriate to continue to pile on subsidized and industrialized guilt to the young and blameless, while seemingly attempting to lead some down a potentially unhealthy path of social contagion and self loathing. This is a moment for critical thinking. This is a moment, as I harp on about in episode after episode, to not repeat the mistakes of the last 10 years. MPs and entrenched interests, many of whom are the exact same ones who got us here in the first place, we can't trust them to police themselves. On that, we're talking to the guy you want to be talking to, Professor Bruce Pardy. Thrilled to have him on the show. This is a great discussion. Stay for the whole thing. And first, a word from our sponsor.
I want to give a quick word from our sponsor, Albertans Against No Fault Insurance. So, did you know that the Alberta government is overhauling its auto insurance system under a new model called Care First, coming into effect in 2027? Most Albertans injured in car accidents will no longer be able to sue the at-fault driver. Instead, decisions about your care and compensation will be made by the insurance company, not your doctor, not the courts. Critics say this system puts insurance companies first and removes key rights from victims and their families.
Bruce Pardy joins the show. Bruce is a professor of law at Queen's University, executive director of Rights Probe, senior fellow with the Fraser Institute and MLI. He's a prominent critic of legal progressivism and the managerial state. He was a real leader to me in Canada during the irrationality and overreach that took over during Canada's COVID-19 response. Bruce, thank you for joining us.
Terrific to be here with you. Thank you for the invitation.
It means a lot. It's almost hard to get into a topic of the day on the shared worry of that legal progressivism at the moment and that expansion of the managerial state. I wish we only had one to pick from. And I know our audience shares in those concerns because I had Dr. Caroline Elliott on the show over the weekend, prominent media critic on Canada's growing DRIPA issue and the behind closed door expansion of Aboriginal title. You wrote recently in the Fraser Institute that Aboriginal rights are now more constitutionally powerful than any charter right. You also expanded on this idea of some people are more equal than others for the Aristotle Foundation. Why do you feel that way, and why does it concern you?
Right. Well. Caroline is absolutely right about the Aboriginal question. Things are proceeding very quickly in a particular direction. They've been on this track for a long time, but it's really becoming acute now, as Caroline no doubt mentioned. The idea that is entrenched in our Constitution that people of different lineage or identity should be given different rights than other people. I mean, it is constitutionally entrenched in this country. It's been around for a long time. And so it's very difficult to challenge because it's constitutional. It's deeply embedded in the culture. People think it's the natural order of things. But of course, it's none of those things, and it is a very dangerous and damaging idea. If you transplanted this idea to other places, other countries, other moments in history, and said, right, all of you people who have some kind of connection to the past through your genes and through your parents have these rights, and those of you who don't have that connection have these different rights. That is the kind of society that you do not want, because that is not a society governed by the rule of law. Let's just make this clear. The rule of law, like, it's a very broad idea, lots of aspects to it, but one of them is that the same laws apply to everybody. And you've immediately breached that idea. You've determined that some people have a different special status than other people, and that's all based upon identity, group affiliation, lineage, and so on. That is a terrible idea upon which to base a country. But we have Section 35, and Section 35 embeds that idea in the Constitution.
Yeah, and so I was just talking to someone in politics about this, where they were lamenting that issue, but they were saying, I don't think average person understands that it is in the charter, that there is this foundational kind of whoopsie here, where we've
Well,
created these protected classes, and maybe you had something second last, and maybe you have a self-identifying feature, and now your rights are more important than others.
in fact, so that there is a section of the charter that is relevant here, but in fact, Section 35 itself, which is the guarantee, is not even in the charter. And
Oh,
so that people might hear that and think, well, that means it's not as important as a charter right. But actually, it's more powerful than a charter right for this reason.
yeah.
It is not even subject to Section 1, which is the reasonable limits clause, and Section 33, which is the notwithstanding clause. In other words, legislatures, both provincial and federal, can use Section 33 to say, well, we're legislating the following thing. Our statute, in case it infringes upon these particular rights, 2 and 7 to 15 of the charter, we're going to just put this in the bill and say that doesn't matter. That's what Section 33 allows you to do. You can't do that with Section 35. So if the courts come out with a decision about Aboriginal title, there is nothing that a legislature can do about it. Nothing. The courts control this, period.
Wow.
And the direction that the courts have been taking us over a long period of time is where we're ending up now. Now, that's not to say that legislators have been opposed to this. They have not, especially in BC, right? So in BC, there are other things going on as well, pushing us in the same direction. The government of BC has been making agreements with specific Aboriginal groups over specific territory, like Haida, for example, that either recognize Aboriginal title or promise to do so in the future. And there's a pretend going on in these agreements that private property rights will be honored. Problem is that Aboriginal title and private property are inconsistent. The two things cannot coexist, because Aboriginal title is communal, private property is obviously private. And Aboriginal title cannot be surrendered to anyone but the Crown. So the idea that you're going to have this private fee simple title on a piece of land that is also covered by Aboriginal title is a complete pretend. It's not true. If you are an owner of fee simple title in an area in which the BC government has recognized Aboriginal title, you've got a problem. And don't be persuaded otherwise.
As somebody who lives in the BC Lower Mainland right now, and is very much a renter because I'm of a certain age and not a foreign speculator or a multi-billionaire, there's a real chill going up amongst the 20-year-olds, 30-year-olds, 40-year-olds, going, okay, like, best case scenario, we can actually afford a dog crate condo one day. What's going to happen to the land beneath our feet? It's so. I know you've tweeted something recently to this effect. I think of these sort of protected classes, and where gee, to know it's enshrined in the charter is alarming to a layman like myself. On DEI initiatives, government DEI, corporate social DEI, are we not engaging in a kind of soft bigotry of low expectations? Would you like to see more space for meritocracy in our culture and in our institutions?
Yes, sure. So DEI. So there's a lot of misunderstanding about this amongst the broader Canadian population, right?
Yeah.
So a lot of people think that there is a basic legal proposition that the same rules apply to everybody, and you can't discriminate against people on the basis of their race or their religion or their sex. Okay, not true in Canada. It is true in the United States. They have a constitutional guarantee of equal protection of the law, and that's what their Supreme Court has recently confirmed that it means. In our country, we have Section 15 of the Charter. Now, Section 15.1 of the Charter appears, by its words, to say essentially the same thing as the American guarantee does. It provides for equal treatment of the law of people without discrimination. Okay? But we also have 15.2, and 15.2 is an exception to 15.1, and it says, in not exactly the same words, reverse discrimination is okay, depending upon who it is you're discriminating in favor of and against. But that's not the whole of it. What's happened over time is the Supreme Court has taken this exception in 15.2 and made it the general rule in 15.1. They've made 15.1 mean the same thing essentially as 15.2. So it is a constitutional imperative in this country that we are that governments are allowed, and in fact sometimes required, to treat different people differently as long as you are discriminating against the right groups. And I bet you can guess what the right groups are.
Yeah, and who gets
Right?
the dictation of the right groups.
That's right.
And
And so this is what DEI means. DEI, diversity, equity, and inclusion, does not mean diversity, equity, and inclusion. It means discriminating against these groups in favor of those groups. It does not mean equal protection of the law. It means equity, which is the opposite. Equity means we're going to treat people differently so as to try to provide for equal or comparable outcomes between groups.
Yeah.
Okay. This is the opposite of a merit-based approach.
Yeah.
It is constitutionalized. Just like the Aboriginal rights provision, this is constitutionalized largely thanks to the Supreme Court. So if you are a person in the wrong in the wrong constituency, if you are especially if you are a white, straight Christian male, then everything is stacked legally and constitutionally against you. That's the way it's been designed.
It was already hard enough out here as a 30-year-old working hard in a Canadian city with all its problems. You highlighted, I loved this speech you just gave, and expanding on these levers of power and things being stacked against you. A 2022 Globe and Mail Freedom Convoy op-ed before the Justice Committee recently. I know that author in his words. It set off alarm bells whenever someone stumbles across it. Now, would you be so kind to tell us, this audience, about that op-ed? Who wrote
Yes,
it? Who wrote
sure.
it, and why the
Yes.
heck does it worry you?
This is a column published by the Globe and Mail in
Yeah.
February 2022. The title: "It's time to stop the sedition by enforcing the law and following the money."
Yeah.
Right? And it said in the column, people have been terrorized for over a week.
Yeah.
Right? February 2022. Right? So who is the author talking about? Well, of course, the trucker convoy. Right? Seditionists and terrorists.
Yeah.
And of course, the trucker convoy: no violence, no weapons, no assaults, no storming of parliament, road hockey, parking violations,
Yeah.
and unkind words about the government. Right? Seditionists and terrorists. And of course, who is the author of this column? Mark Carney,
Ugh.
now the Prime Minister.
Yeah. No, it's so alarming when you read that. I remember that piece coming out, and I was in Ottawa. I was living in Toronto at the time. I was doing media. I'm a third-party director with the National Citizens Coalition, which is very much an organization that does not love big government and big government overreach. And I was writing columns, and I went, you know what? I'm just going. I know that they're seemingly conflating this into a January 6th and Maybe I end up on some endless list, and maybe I actually am, and I don't know about it. But I'm going. I want to talk to these people. I want to cover it. I was doing radio. I did the Greg Brady show a few times. Really expanded my audience and got to know some great journalists. And the moment I got there, Bruce, and I could appreciate that our professional class in Ottawa did not like all the noise and the yobs and the great unwashed to them, seemingly. I arrived to what felt like a music festival. It felt like
Yes.
a
Yes.
particularly. Were you able to attend it? Did
Oh, I was
you?
there. I was
Good.
there most of the time.
I
Yeah.
think I saw you dancing on the truck by the
That's possible.
down at the corner by the Rito Center.
It's possible.
To me, it was like a French Canadian music festival. You had all these folks who
Right.
had been, especially the curfew. You could see the damage psychologically to the rights of these people, to their raison d'etre, that they couldn't even leave the house after dark. And I was talking to crunchy granola moms and light workers and new immigrants who felt like this reminded them of the communist country that they left, Canada.
Yes.
They're going, all the old alarm bells were going off for them. People were hugging. There were a very large Mohawk contingent, which I'm sure you
Yes.
saw as well.
Yes. Yes. Yes.
Terrific beating of the drums and mixed with the deafening horns at times was quite interesting. And so it's
Well, my impression was of a whole bunch of people who were so happy to have found each other.
Yeah.
Because a lot of them have been going through this period thinking, am I the only one who thinks this?
Yeah.
But actually, they weren't.
They were so alienated, so ostracized that many of them drove across the country to raise those concerns, to feel so misrepresented that I find it very emotionally powerful that they drove to our our hall of power to honk out front, to dance, to hug, to reestablish human connection, driving through -40 and barren tundra. It was darn cold too. The lens on my camera kept freezing when I was
I'm
taking
sure it was
photos.
very cold. Yeah, I remember those days.
People
It was
heating their hands
yeah.
by trash barrel fires and soup
Yeah.
kitchens, and so uh, it worries me so much, and I'm so thankful that you highlighted before the Justice Committee those Carney words, because as a free speech advocate, we're so many people are talking Bill C9 right now. The concerns with Bill C9. You yourself, I mean, what do you see as the primary risks that Bill C9 sort of poses to freedom of expression, particularly
Yeah.
in how it might expand the policing of online and public discourse?
Right. So you'll see the psychology here.
Yeah.
The convoy was called by various different kinds of people. The Carney column called them seditionists and terrorists.
Yeah.
The Ottawa police chief called it violence.
Ontario's premier, similarly, a supposed conservative, castigated them as well.
And the police chief was challenged at the commission.
Yeah.
On that statement, he said, "Well, okay, violent. Well, where was the violence? Are you talking
Words
about?
words are violent.
Are you
Right?
talking about like criminal code violence?" And he just backed right off. And no, well, not actual violence.
Yeah.
The violence that the community felt, and of course, the ministers of the government were talking about the violence of a political rhetoric.
Yeah.
Right. We are now into the territory where words are violence.
Yeah.
And you need violence to repel violence of the words that you spoke, right? So this is uncharted territory.
Yeah.
I mean, we've been in this territory for a while now, but nevertheless, we
Yeah.
have crossed the threshold of saying you can say what you want as long as you're not threatening violence.
Yeah.
Well, the truckers did not threaten violence, and they did not commit violence. And yet, the Emergencies Act was triggered because the government perceived an emergency. Now, they were right to perceive an emergency to their political fortunes.
Yeah.
But that's not the kind of emergency the Emergencies Act was designed to respond to. Here you had a group of ordinary people coming together to say to the government, you know what? No, we're not going to go along with this anymore. We don't trust you anymore. We're not complying anymore. We challenge the legitimacy of what you're doing. Now, that is a real political threat when it comes from a groundswell, grassroots gathering of ordinary people right in front of your national legislature.
Yeah.
Okay? So that was the emergency. But C9 is a set of amendments to the criminal code which are very problematic. One of them tries to give a definition of hatred. Now, we have had on our books for a good while an offense of hate speech, essentially,
Yeah.
which, for my money, we should not have. They do not have that in the United States. In the United States, the First Amendment protects language that in this country we would call hate speech. Hate speech is not a thing in the US. It is constitutionally protected speech. But our Supreme Court has said, well, yes, if you're gonna police hate speech, it does infringe free speech, but Section 1 says reasonable limits. So if you do it to this extent, it's okay, and if you do it to this extent, it's not okay. And they tried to give a description of where that line was, hopelessly vague.
Yeah.
But this bill doubles down on that vagueness. It basically says hatred. Number one, hatred is an emotion. So note this: we are now policing emotions. Hatred is an emotion. It says so right in the proposed definition. So we're no longer just policing acts and mens rea. If you commit an act of violence with intent, that constitutes the offense. Okay? That is not this. This is the emotion of hatred, the emotion of detestation or vilification that is stronger than disdain or dislike. Okay, well, so now they're trying to draw the line. And this resembles the language in the Supreme Court decision, but it's not exactly the same. Very close, though. So, but here's the problem. So they've said detestation is criminal, but dislike is not. So there's your line. But hold on, wait a minute. What does detestation mean? If you look it up, it means intensely dislike. So here's our legal line. You're allowed to express and have the emotion of dislike, but it's criminal to intensely dislike. Okay, now where is the line between dislike and intensely dislike? Nobody knows that.
That we have a thesaurus deciding this evidently that's deeply, deeply concerning. Like, are there any adequate safeguards?
No.
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 Just
I mean, the safeguard that people will cite is, well, but this won't happen. We won't be convicted of anything related to this except by a court. So the court is the gatekeeper here, and therefore we can be confident that things won't go awry. Well, the problem is that it is the Supreme Court of Canada that has sent us down this path in the first place.
Yeah.
And are willing to give ground to governments that want to censor speech. All right. Now, there's another aspect, and there's several aspects, proposed amendments in this C9 bill. But another one is a one that would be able to target protests. So this one says that if you near a building or something, you're let's say you're protesting, if you intend to, quote, create a state of fear, then you could be guilty of this criminal offense. Now, creating a state of fear, here's what they do not mean. They don't mean creating a state of fear of violence. They don't mean that somebody has made threats, because we already have an offense for that. That's an assault. You can't threaten violence. That makes sense. You can't go up to somebody in the street and say, I'm going to hurt you unless you give me your wallet. You can't do that. This is not that. This is if you create a state of fear in somebody of what? Well, who knows? The state of fear may be the kind of state of fear that the residents of Ottawa complained about when the truckers were there. Like the state of fear of these ugly, horrible, offensive ideas.
Phantom honking and
the rhetoric of a political ideology.
Yeah.
Right? Now you're into the thought police. And the potential is that this kind of a section could be applied to a future version of the trucker convoy.
The worry is, too, for me as the non-charter expert here, is it's also the way they refer to their opposition. Everything is fear-based, and this sounds like political violence, and you're blowing a dog whistle. If they're using the same language there, if they're using the same language of these special interests who receive big government subsidies to do some hate research and to ostensibly log roll for more government power and to get more things passed, does Pierre Poilievre become guilty of that?
Well, so they're going. So the number of prosecutions of hate speech under the criminal code is very small. It's
Okay.
something that, I mean, there was a bill in the last Parliament, C-63, that was also a speech bill,
Okay.
and it was even more problematic than C-9 because it included amendments to the Canadian Human Rights Act, and it's much easier to get a complaint against you under the Human Rights Tribunal Commission regime than it is to be prosecuted for a criminal offense. Because at least with the criminal offenses, you still have beyond a reasonable doubt as the threshold. You have evidentiary requirements and so on and so forth. You still have all the protections that attach to a criminal prosecution. Not so with a human rights complaint. And so that would have been a much more problematic. And by the way, this may be coming back in a new bill, but
More good news. Okay.
yeah, more good news. But
Yeah.
that is the kind of thing that's going to affect a larger, broader number of people. You'd still hope that the number of actual criminal prosecutions wouldn't get out of hand, but there's no guarantee. But the human rights thing, I think, is more problematic even.
Bruce Pardy, that was a lot to digest. I'm trying not to red pill myself, black pill myself. I'm let's hope we're wrong about a few of these things. You were such a prominent figure who stood athwart the worst of the COVID years and violations of the charter. I wanted to ask you, has Canada gotten over, some of its issues with the madness of crowds? Are we better equipped to deal with social contagion? Do we still have much to learn? But I think what we're hearing right now is it's going to be a challenging few years.
Oh yeah, I don't think there's been a reckoning of the COVID
No, there hasn't. Yeah.
disaster. I don't think I doubt that there's going to be one. It just it's too difficult for the powers that be to own up to what happened. And in fact, I've been saying that COVID, rather than a mistake, is viewed by the powers that be, by the administrative state, as its greatest triumph. I mean, after all, they controlled the game.
They got away with it.
What it aspires to do, right? So
Yeah.
it's not like they think it was a series of mistakes.
No, we're relying on them to police themselves on this,
Yes,
to
and
show
that is the
contrition.
key. That is
Yeah.
the key problem with the way we are governed, with the
Yeah.
way our Constitution works, with our systems of law. We are depending upon the people with power to restrain themselves,
Yeah.
and that is not a good way to proceed.
And sadly, they figured out that they can really, push that as far as humanly possible.
Yeah,
Professor, thank you so much for joining us. This was incredibly insightful.
it's my pleasure. Thanks for having me.